Rise and shine. It's time to grind, my fellow Americans. Today it is nearly 6 a.m. or so. Great time to be awake, great time to be alive, great time to be grateful. Today we're going to work on more study guides from the book. Before I get started here, I do want to say one thing that I truly believe in, and that is to get ahead, you got to stay ahead. And we can ask, what the hell does that mean? Well, to get ahead, we all have the same amount of time in a day. We have 24 hours in a day, right? 24 hours a day, 7 days a week. And a lot of this time is wasted. People they scroll through a phone, they watch a lot of TV, which I could say I watch my fair amount of TV, but at the same time while I'm doing that, it's background noise. Put on a show or two, and I sit there and I read my books and I write my papers. So sometimes I don't even really watch it. But I do need to take my own advice at times. However, we have 340 million Americans in the United States. Okay? I read something very interesting that we have the world's largest army. And this is why a lot of countries do not invade us. It's not the Army, the Marines, the Navy, the Air Force, none of that. That's nothing compared to what's in the backyards of each and every American's homes. Our homes are full of guns. Some homes are full of probably explosives and other things that really can lead to some serious repercussions if somebody was to invade us. 340 Americans, we have about 600,000 people, 600,000 person standing army just in one state alone. I believe that's Wisconsin. And how we can say this is based on statistics. Statistically, there are 600,000 people, I believe, in Wisconsin that had gone and got their hunter's license. That's a bigger army than Germany. That's a bigger army than South Africa, than Italy, and so on. Our country does not play, but when it comes to our rights and when it comes to our time, we sure do waste it. We sure do sit around. So back to 340 million Americans. Okay? The reason I say this is because only about 8% of those Americans wake up they actually use their time efficiently. They wake up about 5 a.m. That's statistically proven. 8% of people wake up at 5 a.m. The rest generally wake up from 7 a.m. or later, okay? Well, you get this. If you go to bed and you get your efficient amount of sleep, 8 hours, you get 8 hours sleep, what do you have left in the day? You have 16 hours left in a 24-hour span. So what are you going to do with that 24, or what you can do with that 16 hours? Go to bed early, 7, 8, 9 o'clock, get up 5 a.m. This means you're in the 8th percentile range of people getting up. That's 27,200,000 people out of 340 million Americans. So you're in the 8th percentile. That's waking up at 5 a.m. Now, if you wake up at 5 a.m. and generally everybody else wakes up at 2 or at 7 a.m., that's 2 hours before. You are now awake 2 hours before everybody else. Now, if you do this for 360 days, you're now 720 hours ahead of the 92% that sleep into 7 a.m. to whatever, 11 a.m. or so, even past that. Anyways, so you go on to 2 years, you're 1,440 hours ahead of the rest of the people. You do that for 3 years, you're 2,160 hours ahead of the other 92 percentile range. Okay? And then if you do this for 6 years, such as I have, that is 4,320 hours ahead of the others. So try to catch up to that. What do I do at that time? I get up and I work out and I read. I write my papers. Before I even started school, I got up and I read and I wrote. I made sure I had hydrated myself. I made sure that I just took care of myself before the rest of the world was awake. And now, to get ahead, I had to stay ahead. I had to continue getting up at 5 a.m. And I had to, or sometimes it was 4 a.m. Sometimes it became 6 a.m. It just, in between those, whether you're getting up 2 hours ahead of everybody else or an hour, it's still beneficial for your mind, your body, and spirit. See, Benjamin Franklin said a young, what was it? To stay young, wealthy, and wise, a man goes to bed early and wakes. I can't remember the exact quote, but it's something about going to bed early and waking up early. And this is what keeps a man young, wealthy, and wise. Early to bed, early to rise makes a man young, wealthy, and wise. That's it. Benjamin Franklin. And that quote stuck with me. I found that when I was about 25. And it stuck with me. Early to bed, early to rise keeps a man young, wealthy, and wise. Okay? Alright. I think it's time to carry on. Today, we're going to be talking about, well, I think we went over the judicial canons yesterday. And today, we're going to go over what are the civil rules of procedure, federal rules of evidence, and judicial canons. So, we can go over some of this today. It's actually a lot. But that's cool. So, what are the civil rules of procedure, federal rules of evidence, and judicial canons? These are the 3 pillars of the United States legal system, each serving a different but critical purpose. So the civil rules of procedure. And if you did not watch the videos from yesterday, perhaps you should go do that, because that was a very good video. So, and I mean, you should go watch it from the first video till now. There's going to be 5 videos. So yes, the civil rules of procedure, the federal rules of evidence, and the judicial canons are the 3 pillars of the United States legal system. This is what you use when you're in the court of law. It is not just about the law, just about the Constitution. You want to go in there and play their game the way they play it. Use these 3 pillars. Civil rules of procedure, these are the rules that govern the steps of a lawsuit, how it begins, moves through discovery, gets to trial, and even how appeals work. There are 2 major sets. Federal rules of civil procedure, the FRCP, for lawsuits in federal court, and then state civil rules like Illinois Code of Civil Procedure. So each state will have their own code of civil procedure. They will have different names for them, and yeah. For state court cases, key topics they cover: pleading and filing requirements, discovery rule 26 plus. So there's 26 plus rules. There's the motion, like motion to compel. Motion to compel is very interesting because this is what you use when you are in discovery. Discovery is where you use interrogatories, and discovery is where you basically put somebody under the spotlight, cameras, action. And now oath. Oath is the most important thing. They're under oath, and they have to answer the questions that are being asked of them. And if they don't answer these questions, they don't want to ask or answer the interrogatories, you go ahead and you file a motion to compel, which is Rule 37. So then there's the summary judgment. The summary judgment is basically, summary judgment is like if, let's say you file a complaint and then in 30 days the defendant nor the lawyer responds. They don't even respond with a motion to dismiss. They just don't say anything. So now you file a summary judgment based on them not responding. Non-response means that stands truth in the court of law, and you won your case. So then we have trial and appeal process. So the Federal Rules of Evidence, FRE. So the Federal Rules of Evidence, what governs what evidence is allowed in court, especially during hearings and trial in federal court. They cover relevance rules 401 to 403, hearsay and exceptions, Rule 801 plus, witness testimony, Rules 601 to 615, documents, emails, photos, etc., Rules 901 to 1001. And this right here is the idea I got to make my evidence binder. The Federal Rules of Evidence, this is what I have evidence of. Documents, emails, I even have photos. I took photos of all the stuff I sent certified mail. All of that is beautiful to have. If you want to introduce a letter, video, or statement at trial, these rules determine whether it's admissible. Okay? So then we're going back to the judicial canons, which we went over. These are the rules of ethics and behavior for judges. They're not laws per se, but they're enforceable by judicial disciplinary boards. So basically, when you go to appeals, you go to the judicial canons, and you can have the judge reprimanded for what he has done wrong. If he has violated your rights and you can prove so, then there will be consequences. So the canons cover, again, impartiality, avoiding bias, transparency, recusal. Recusal is when the judge should remove themselves. That's basically where now you go ahead and you file your complaint against the judge, and yeah, it's basically the judge has been biased. They have been very extremely impartial. They haven't been transparent, and so you file a recusal, remove the judge, and now another judge is appointed to the case. So then we have a demeanor and professionalism. Very important, as I said yesterday, demeanor and professionalism. You should cite the canons if a judge shows clear bias or violates public trust. Everything is a trust, everything is a contract, whether it's tangible or intangible. All public representatives have a fiduciary obligation, a fiduciary responsibility to basically benefit the beneficiaries. That's the simplest way to put it. Alright, so what is Rule 26F? Meet and confer. And how do you do it? So this is a very important. Meet and confer is something that's expected based on the rule of civil procedures. This is part of the Federal Rules of Civil Procedure, specifically Rule 26F. This requires both parties in federal civil case to meet and confer remotely, either in the case, usually within 21 days after the defendant files an answer. So once they file an answer, once Mercy Housing files an answer, I'll be required to do a meet and confer before the court issues scheduling order. So what do you do during Rule 26F, meet and confer conference? Discuss the claims and defenses, plan discovery, what each side needs to get, talk about electronics, evidences, emails, files, etc., discuss settlement or alternative dispute resolutions, and then 5, create a joint proposed discovery plan sent to the judge. So all of those are very important to do, to understand. There's definitely, you have to follow the civil rules of procedure, because this is when they go ahead and they file a motion to dismiss because the rules weren't applied, they weren't followed, and so on. And a lot of people don't know this stuff, but this is why I'm here, to advocate for these things, to make this clear. This is what we should do, this is what you need to do, this is what we all should do, this is how we become, instead of infants of unsound mind in the court of law, we sound like educated adults, essentially, that now have the ability to respond. How to request or schedule one, or schedule a meet and confer. Typically, you send a letter or email to opposing counsel, and once you file your complaint, they are summoned. Once they are summoned, they typically should respond, and when they respond, you can go ahead and get the information of the opposing counsel. The opposing counsel is their attorney or corporate lawyer, and you get that information, and now you contact them by way of, and there's probably other information on there as well. I'll find that out soon. I'm not sure, but I'm sure their email is there. So you send a letter or email to opposing counsel proposing dates to meet by phone, video, or in person. If they refuse or stall, which is what a lot of people's response is, a lot of people, and I don't mean the counsel, I mean us, the people. A lot of people are like, well, they won't respond, they won't listen, they won't do what they're supposed to do. Well, when you know how to tell them what to do, when you know how to nudge, shove them around by following these things, these procedures, they have to listen. You get the judge involved, the judge don't listen, well, then you file a recusal, and so on. If they refuse or stall, you can file a notice with the court stating that you're ready and they won't cooperate, which looks bad for them, of course. They have more of an obligation. It's more obligatory for them to follow the professionalism, the code of conduct when it comes to professionalism. So, because they are bar card lawyers, they did go to school, they're more lenient with pro se litigants. Not that lenient, but they are lenient. Because, well, you're a pro se litigant, you're not a bar card lawyer, you didn't go through all this stuff that they went through. So, as I said though, hold up a code of conduct. You are representing yourself, your name, your person. So, keep at it. Here's an example. Email to the opposing counsel. Okay, so I have an example if I was to email them, which that's probably what I would do. I would rather email them than go ahead and mail them. Mail will take too long. Email will be real quick. I'll go ahead and I'll say, Dear Counsel, pursuant to Rule 26F of the Federal Rules of Civil Procedure, I'm requesting that we schedule a discovery planning this conference within the next 2 weeks. Please advise your availability for a phone or video meeting to discuss the scope and schedule of discovery. Respectfully, me, Tony David Leonard, R.E. Leonidas Hamza, attorney in fact for the principal, Tony David Leonard. So, carrying on, does a motion to compel need to be notarized? No. A lot of documents don't need to be notarized. It's typically affidavits that need to be notarized. So when you file the motion to compel, it is not a sworn affidavit. You sign it yourself, type name or physical signature, and include a certificate of service showing you sent the copy to the other party. Okay? So that's something you need to do as well. You need to send it to the other party. Only affidavits, declarations, or sworn statements attached to motions need to be notarized if they're being used as evidence. So your motion to compel should include the motion body, which a certificate of service at the bottom, and your signature. And if it's a type signature, you do /s/. Okay, that's how you do a type signature. Again, I'm in the public gym, and people are waking, they're rising. So I'm just watching to see if anybody comes in here. I guess they'll be a part of our video. Okay, so if you want to study further, if you want to study the Federal Rules of Civil Procedure, you can go to Cornell Law. Cornell Law is what I use extravagantly. Federal Rules of Civil Evidence, Cornell Law. If you are in Illinois Rules of Civil Procedure, you can go look at that at the Illinois page, illinois.gov or something like that. Illinois Code of Judicial Conduct, same thing. You can go look at that at the state page. Okay, so that right there is a really good summary of what all this is. And then if you want to listen to this real quick, I have a cutout of Federal Rules of Civil Procedures, and then we will wrap this up for the day. So I have, as I said, I don't have all the rules because this is particularly a study guide for my case in the current moment, and these are general rules in which I should use for this particular matter. What is that noise? I don't know. Okay, so Rule 8, General Pleading Rules. Complaint must state a claim for relief. Defenses must be stated in the answer. Okay, so complaint for state of relief, I put in the prayer for relief, and this is what I want. I want an apology, a written apology. I want a written confirmation that the false allegations against my person is removed completely from my transcript with the whole entire rental company. I want to be reimbursed monetary funds for all the time, stress, duress, and extortion. So those are very important words to understand: stress, duress, fraud, and extortion. Look those words up. Rule 12B6, motion to dismiss for failure to state a claim. That was the rule. What was that? 26 or something like that. But anyways, motion to dismiss for failure to state a claim. The defense may try to use this. Your job is to show your complaint lays out facts plus law clearly. Okay, so basically, I will get up there, and if they file a motion to dismiss for failure to state a claim, I'll get up there and I'll say there was a duty, breach, and damages. Duty, breach, damage, and basically the duty was to uphold the contract we had against each other. The breach was when they made false allegations against me that caused harm, and then damages, and then I laid out the damages already. So duty, breach, damages. Remember those. Stress, duress, fraud, and extortion. Duty, breach, damages. Okay? Don't forget those things. Carrying on, Rule 26, discovery duty. Parties must disclose evidence, witness list, and keep communication fair. Includes Rule 26F, conference. Meet and confer. Rule 33, interrogatories. So interrogatories, you can have up to 25 questions in Illinois. Written questions you can send to defendants must be answered under oath. Okay? And something that's very important, like when you're doing anything under oath, you want to reserve your rights. I don't know if you would speak it out loud and say without prejudice. Maybe that's something I'll do. I don't know if that's necessary, but on all documents, you always sign without prejudice, okay? Rule 34, production of documents lets you demand documents or emails, records, files. Rule 37, motion to compel. If they refuse to give discovery, this is your enforcement tool, motion to compel, okay? And that the judge will have to force them to compel or to comply with your demands, because they could say that what they have and they're not willing to give could be evidence that can make things all that much more clear in the court. Rule 56, summary judgment. There's summary judgment again. Decides the case without trial. If there's no genuine dispute of material fact, you'll need this both defensively if they file it and offensively if they want judgment. Okay? So there we go. Here's some key ones. Here's some key federal rules of evidence for my case. Rule 401 to 402, relevance. Only relevant evidence comes in. Rule 403, excluding prejudice. Court may exclude evidence if it causes unfair prejudice, confusion, or waste of time. Rule 404B, character evidence. No bad character evidence to show you acted that way before. Rule 602, personal knowledge. Witness must testify only to what they saw and heard themselves. Rule 701, lay opinion. Non-experts can't give expert-style opinions. Rule 801 to 802. Hearsay. Out of court. Statements generally not admissible unless exception applies. Rule 901. Authentication. Documents, emails, photos, etc. must be authenticated, verified by sender recipient. Rule 1002. Best evidence rule. The original document is required unless a valid exception applies. Okay? And here's the thing about that, right? The best evidence rule, the original document is required unless a valid exception applies. A lot of documents cannot be presented. A lot of documents cannot be put forth because a lot, like let's say if you was to go sue them for your lease because you signed without recourse and such, a lot of the times they take these negotiable instruments and they take them to their, well, the assistant property manager, the property manager have no clue. However, they take these documents and they take them to their financial companies, and the financial companies will go ahead and they'll securitize, monetize these instruments, and they'll exchange them with Series 10 and their Series 10 and Series 7 brokers. These are banker terms, and they'll exchange these negotiable instruments with the Federal Reserve discount window, and there they will go ahead and it will all be it will be exchanged for monetary funds, for basically Federal Reserve notes. So anyways, long story short, your rent's already paid. Your rent's already paid, your car note's already paid, your mortgage is already paid, everything is already paid before you walk out the office, basically, because you endorsed everything. But you endorsed everything with a blank signature, and that was your fault. And that's how these corporations get everybody. So if you was to go there and say, produce the original instrument, can they produce the original instrument? No, they usually cannot. That will come later. That's a lot to do with UCC Article 3, which is negotiable instruments, and UCC Article 9, secure transactions. Those are banker words right there in those outlines. Okay? Well, I'm done. This is enough for today. We'll get back to this tomorrow, make another video, keep going throughout the month or two, and see what I can put together here. Alright, thank you for your time. Have a blessed day. Peace out.